Good afternoon, class. So today we will be discussing a very important topic, in human resource management and labor law, the employer-employee relationship. Now, this topic is crucial because before any labor right, obligation, or dispute can exist, we must first establish whether an employer-employee relationship exists. So without it, labor laws generally do not apply. Now, for our learning objectives. So by the end of this lesson, students should be able to, number one, identify when an employer-employee relationship exists, discuss the fourfold test used to determine the existence of an employer-employee relationship, and differentiate job contracting from labor contracting, and recognize the legal principles governing recruitment, placement, and protection of workers. Now let's talk about the first stage, of employer-employee relationship, which is pre-employment. Now, as the term suggests, class, pre-employment refers to everything that happens before a person officially becomes an employee. At this point, there is still no employer-employee relationship, but the law already steps in to regulate the process. Now, let's talk about pre-employment stage. This stage covers activities such as recruitment, hiring, placement. Now, these activities are governed by Book 1 of the Labor Code, which deals specifically with pre-employment. Now, the purpose of regulation at this stage is protection. That is to make sure that job seekers are not abused, misled, or exploited even before they are hired. Next is the recruitment and placement. Now, under Article 13, paragraph B of the Labor Code, recruitment and placement refers to any act of canvassing, enlisting, contracting, transporting, utilizing, hiring, and or procuring workers, including referrals, contract services, or advertising employment, whether for local or overseas work. Now, take note of the two important points here. First, recruitment is very broad. It is not limited to hiring. Even advertising jobs, and also making promises of employment or referring applicants may already be considered recruitment. Now, second, um, recruitment may be done with or without a fee, directly by the employer or through an agent. That is why government activities are strictly regulated by the government. Now, why is pre-employment or why pre-employment matters in HRDM? So class for HR professionals, this stage is critical because it shapes the quality and credibility of the workforce. It protects applicants from illegal recruitment. It ensures fairness, transparency, and compliance with labor laws. So, even before employment begins, take note that HR already carries legal responsibility. Now, remember this, class. Recruitment and placement exist to ensure that qualified individuals are properly matched with legitimate employers under government regulation to protect workers. So this means recruitment is not just about filling vacancies. It is about ethical hiring, legal compliance, and social responsibility. So always remember, employment does not begin at hiring. It begins at recruitment. And HR's role begins even before the first day of work. Okay. Now that we understand what recruitment and placement mean, let us identify who are legally allowed to engage in these activities. No? So this is very important, especially in HR, because not everyone who recruits is legally authorized to do so. So we have here number one, public employment offices. This includes government offices such as DOLE and PESO or the Public Employment Service Office. Now, their role is to assist job seekers and employers by facilitating employment free of charge. Since they are government offices, their recruitment activities are presumed legal and regulated. Next, we have private employment agencies. Okay, so these agencies are allowed to recruit, but only if they are licensed by the Department of Labor and Employment. Take note, class, that without a DOLE license, a private agency cannot legally recruit, especially for profit. This requirement protects applicants from illegal recruitment and exploitation. Third are recruitment entities with valid authority. So this includes licensed overseas recruitment agencies, particularly those authorized under POAA rules. Because overseas employment involves higher risk, the law requires stricter regulation, licensing, and monitoring. Fourth, we have employers themselves may recruit directly for their own company. So this is perfectly legal, no? As long as they are hiring workers for their own use and not for placement in another companies. Now, let's take note of this important rule. Individual or groups without a DOLE license cannot engage in recruitment for profit. However, there is an exception. Organizations such as churches, civic groups, or community organizations may recommend workers, provided that number one, they do not charge any fee and they are not engaged in recruitment as a business. Now, all these rules, class, are based on Article 13 to 31 of the Labor Code and the POEA rules and regulations. So, as future HR professionals, remember recruitment is not just about finding workers, it is about doing it legally and ethically. So, you have to always check who is recruiting, um, whether they are authorized, whether fees are involved, because unauthorized recruitment class can lead to serious legal liability. Okay? So the next time you see a job offer, you have to ask, is this recruiter legally authorized? Because that simple question can prevent illegal recruitment and protect both workers and employers. Okay. Um, let's discuss prohibited practices in recruitment and placement. So again, even at the pre-employment stage, the law clearly sets boundaries. Under Article 34 of the Labor Code, certain acts are expressly declared unlawful for any recruiter or placement agency. Why? Because recruitment involves power imbalance. Job seekers are vulnerable and the law exists to protect them. So, under Article 34, the following practices are prohibited. Number one, charging excessive or illegal placement fees. Now, note that recruiters are not allowed to charge fees beyond what the law permits. Any excessive, unauthorized, or illegal placement fee is a violation. So this prevents recruiters from profiting unfairly from job seekers' desperation. Second, we have misrepresentation in job offers or contracts. Now, recruiters must tell the truth. So if they promise higher salaries, better working conditions, or different job positions than what actually exists, that is illegal misrepresentation. Next, we have recruiting for job harmful to health or morality. Now, recruitment for work that is dangerous, immoral, or harmful to health is strictly prohibited. The law values human dignity over profit. Next, we have inducing workers to quit employment unjustly. So, recruiters cannot convince or pressure workers to leave their current jobs without valid reason, especially if done for personal or business gain. Now, this protects both employment stability and industrial peace. Next, we have substituting approved employment contracts. So, once a contract is approved, especially in overseas employment, it cannot be replaced with a worse contract without the worker's consent. Contract substitution is one of the most common forms of recruitment abuse, and again, it is illegal. Next, we have failure to deploy workers without valid reason. So, if a recruiter accepts workers and fees but fails to deploy them without a valid reason, that is also a violation. Recruitment is not just about promises, it involves actual placement. Then, seven, we have engaging in recruitment without a license. Recruitment without a valid license or authority is illegal, period. No license means no legal right to recruit, regardless of intent. Now, the key principle behind all these prohibitions is simple. Recruitment must be honest, transparent, and protective of the workers' welfare. Recruitment is not a business opportunity to exploit, it is a regulated activity with social responsibility. So, as future HR professionals, always remember this, class. Not all recruiters are legitimate. Not all job offers are legal. And HR must be the first line of defense against abuse. Knowing these prohibited practices help you avoid legal liability, help uh, protect applicants, and uphold ethical hiring standards. Okay? Now, let's talk about mandatory remittance. Okay, so this is also another important topic in pre-employment and overseas employment regulation. Oh, the mandatory remittance. Now, this concept, class, applies mainly to overseas Filipino workers and reflect both economic policy and social responsibility. Now, what is mandatory remittance? So, under Republic Act 8042, or the Migrant Workers Act, and Republic Act 10022, all overseas Filipino workers are required to remit a portion of their foreign earnings to their families in the Philippines. Now, mandatory remittance refers to the legal requirement imposed on certain OFWs to regularly send a portion of their earnings back to the Philippines, usually through authorized banks or remittance channels. This policies is not meant to punish workers, but to ensure that the benefit of overseas employment extend beyond the individual worker. Now, let us look at the three main reasons behind this policy, class. Number one, financial support to dependents. Now, mandatory remittance ensure financial support to dependents. Many OFWs leave the country to provide for their families, children, parents, or other dependents. The law recognizes this reality and ensures that a portion of the workers' earnings actually reaches the people who rely on them for daily support. Next, we have remittances contribute significantly to the country's foreign exchange reserves. So OFW remittances strengthen the Philippine economy, support the value of the peso, and help stabilize national finances. In short, class, overseas workers play a vital role not only in their families' lives, but also in national economic development. Third, mandatory remittance promotes responsible financial management among OFWs. So, by encouraging regular remittances through formal channels, the government helps OFWs develop saving discipline, avoid unsafe or illegal remittance schemes, and plan for long term financial security. Now, from an HR and legal standpoint, mandatory remittance shows how employment regulation goes beyond the workplace. It demonstrates that labor law can protect families, influence economic policy, and guide responsible behavior among workers. So, when we talk about overseas employment class, remember it is not just about earning abroad. It is about responsibility to family, to the country, and to the future. All right. Now, let's talk about the consequence no, of non-remittance, particularly again in the context of overseas employment. So earlier we discussed that mandatory remittance is not optional. When this obligation is ignored or violated, the law imposes serious administrative consequences, not as punishment, but as a means of enforcement. So let us go through this consequence one by one. Number one, the employer will not be issued accreditation. Accreditation class is a requirement before a foreign employer can legally hire Filipino workers. So if the employer fails to comply with remittance requirements, the government may refuse or revoke the accreditation. And without accreditation, the employer cannot hire Filipino workers legally and deployment will not be allowed. Second, passports issued to Filipino contract workers will not be renewed after expiration. So this consequence directly affects the worker's legal ability to remain or work abroad. So it shows that compliance with remittance rules is tied not only to the employment but also to the documentation and legal status. Third is renewal of employment contracts will not be approved. So even if the worker and employer agree to continue the employment relationship, the government may withhold approval if remittance obligations have not been complied with. This emphasizes that overseas employment contracts are not purely private agreements. They are subject to government regulations. And finally, no license or authority shall be issued to the recruitment agency. So, recruitment agencies that fail to ensure compliance with remittance requirements may also lose their right to operate. And take note, without a license, the agency cannot recruit, they cannot deploy workers, and may be subject to further sanction. So the important lesson here, class, is this. Non-remittance affects everyone involved, employers, workers, and recruitment agency. So from an HR and policy standpoint, these consequences show that overseas employment is highly regulated, compliance is a shared responsibility, and government intervention exists to protect workers and national interests. Now, let's turn on to an important concept in labor regulation, the regulatory and visitorial power of the DOLE Secretary. This topic class explains why and how the government is able to supervise employers, recruitment agencies, and workplaces even without a court case. Okay, let's begin with regulatory powers. So regulatory powers refers to the authority of the Secretary of Labor and Employment to set rules, issue permissions, and regulate compliance in matters involving employment and recruitment. Now, under these powers, the DOLE Secretary may, number one, issue, suspend, or revoke licenses um, of recruitment agencies. Take note that recruitment agencies cannot operate as a matter of right. They operate only by authority granted by the state. So if an agency violates labor laws or recruitment rules, the DOLE secretary may suspend its license or revoke it entirely. Now, this protects workers from abuse or illegal recruiters. Next, we have approve and monitor employment contracts. So, employment contracts, less especially for overseas workers, are subject to government approval. The DOLE ensures that contracts comply with labor standards and workers are not subjected to unfair terms. This prevents exploitation before deployment even happens. Third, regulate recruitment fees and employment standards. The DOLE secretary also has the power to regulate how much recruiters may charge and enforce minimum employment standards. Now, this prevents excessive fees and ensures fair and humane working conditions. Let us move on to visitorial powers. Visitorial powers refer to the authority of the DOLE to enter workplaces and inspect records to check compliance with labor laws. So, unlike court proceedings, these powers are administrative and preventive. Okay, so they inspect workplaces and agency records um, to determine whether labor standards are being followed. Take note, class, that this ensures compliance even without a complaint. Second, they investigate complaints or violations. So, when workers file complaints or when violations are suspected, the DOLE may conduct themselves investigations. These allow the government to act quickly and efficiently, especially in urgent cases involving worker welfare. And last one, enforce compliance order. So, after inspection or investigation, the DOLE secretary may issue compliance orders requiring employers or agencies to correct violations, pay deficiencies, or comply with the labor standards. So, failure to obey these orders may result in sanction or penalties. Okay, take note of that one, class. To a very serious topic in labor law, illegal recruitment. So, this is not just an administrative issue. Illegal recruitment, class, is a criminal offense, and in serious cases, it is treated as economic sabotage. Okay, so let's define illegal recruitment. Under Article 38 of the Labor Code, illegal recruitment is defined as any act of recruitment and placement without a valid license or authority, or any recruitment activity by non-licenses or non-holders of authority. So simply put, if a person or entity recruits without proper authority, the act is illegal regardless of intent. Now, the law recognizes three forms of illegal recruitment depending on the manner and scale of commission. Number one, we have simple illegal recruitment. So this is committed when recruitment activities are performed by unlicensed individuals or entities. Now, note that even one act, such as collecting fees, um, advertising jobs, or promising employment, may already constitute illegal recruitment. Second, illegal recruitment in large scale. So, this becomes large scale class when it is committed against three or more persons, regardless of the amount of money involved. So this is considered economic sabotage, which means heavier penalties and a stronger interest of the state in prosecution. The law focuses on the number of victims, not the value of the fees collected. And then we have illegal recruitment by a syndicate. Illegal recruitment is committed by a syndicate when it is carried out by three or more recruiters acting together. Here, what matters is the number of offenders and their coordinated action. Like large scale illegal recruitment, this is also treated as economic sabotage. Now, take note class that license and authority are essential. Intent is irrelevant. The act itself is punishable. And the victims are protected regardless of how much money they lost. So do not be confused with illegal recruitment in large scale and illegal recruitment by syndicate. Again, illegal recruitment in large scale class is committed against three or more persons. So ang victim, three or more persons. While illegal recruitment by a syndicate, this is committed when it is carried out by three or more recruiters acting together. So ang offender ani, no, ang daghan, ang three or more. Uh, for HR professionals class, understanding illegal recruitment is vital because kamo man ang involved, 'di ba? Ang HR man ang involved sa screening, recruiters or partners. So HR must protect applicants from fraudulent schemes because failure to detect illegal recruitment can expose companies to legal and reputational risks. Now, you have to remember this rule. Recruitment without authority is illegal, and recruitment affecting many victims or done by many recruiters is a serious crime. So you always remind job seekers and yourselves, verify licenses, be cautious of promises, and when in doubt, report. Because illegal recruitment does not just steal money, it destroys lives and opportunities. Okay? Now, let's move on to who can be held liable. Okay? So the law is very clear. Liability is not limited to the person who directly recruits. No, several individuals may be held accountable depending on their participation. So first are the principals. So kinsa man yung mga principal? These are those who directly commit the act of illegal recruitment or cooperate in its commission by an indispensable act. So in simple terms, these are the main actors, the ones who actively carry out or control the illegal recruitment activity. Second are the accomplices. So accomplices are those who cooperate in the commission of the offense, but those participation is not indispensable. So for example, a person who assists in collecting fees or referring applicants, knowing that the recruiter has no license, may be considered an accomplice. Then third, we have accessories. So accessories are those who know that illegal recruitment has been committed and assist the offender afterward, such as by helping conceal the crime or benefit from its proceeds. Their participation comes after the fact, but the law still holds them accountable. Now, this part class is very important no, for HR and corporate settings, the liability of juridical persons. So when illegal recruitment is committed by a juridical person, such as a corporation or partnership, the corporation itself cannot be imprisoned. And therefore, under Section 6 of Republic Act 8042, the officers who have control, management, or direction of the business shall be held criminally liable. So, kinsa man ni sila? This includes presidents, managers, directors, or other responsible officers. So, in other words, corporate officers cannot hide behind the corporate veil. Now, criminal liability follows participation and control, not job titles. You have to take note of this. Meaning, anyone who participates, assists, or allows illegal recruitment to happen may be held criminally liable. Now, for HR professionals, this means ignorance is not a defense. Delegation does not erase responsibility, and compliance systems protect both worker and management. Now, let's discuss prescription of action. So, which refers to the time period within which a criminal case must be filed. Okay? Once this period lapses, the action can no longer be prosecuted. So, in illegal recruitment cases, the law sets different prescript- prescriptive period depending on the seriousness of the offense. For simple illegal recruitment, the criminal action prescribes within 5 years. This means the state or the offended party must file the case within 5 years from the commission or discovery of the offense. If no case is filed within this period, the offender may no longer be prosecuted. So you take note, it's within 5 years. For illegal recruitment constituting economic sabotage, that is katong large-scale illegal recruitment or illegal recruitment by a syndicate, the action prescribes within 20 years. The longer period reflects the serious harm caused to multiple victims and to the national interest. Now, why the difference matters, class? Take note that the law recognizes that simple illegal recruitment affects fewer victims, while economic sabotage involves widespread abuse and organized activity. Thus, greater harm means a longer time for prosecution. Again, simple illegal recruitment, it prescribes within 5 years, but illegal recruitment as an economic sabotage, it prescribes within 20 years. Okay. Well, let's talk about venue, which refers to where the criminal action for illegal recruitment should be filed. Now, venue is important class because filing the case in the wrong court may result in dismissal or delay. So, as a general rule, criminal actions for illegal recruitment shall be filed with the regional trial court. But the law gives two possible venues. So, um, a criminal action for illegal recruitment may be filed in the RTC of the province or city where the offense was committed or where the offended party actually resides at the time the offense was committed. So, this rule is intended to make it easier for victims to seek justice, especially since illegal recruitment often involves victims from distant provinces. Now, take note of this very important rule. The court where the criminal action is first filed acquires jurisdiction to the exclusion of all other courts. This means that once a case is properly filed in one RTC, other courts, even if it is also proper venues, can no longer take cognizance of the case. So this prevents forum shopping and conflicting rulings. Um, Why this rule matter, class? Because illegal recruitment cases often involve multiple victims, different locations, and transactions done in several places. So the law simplifies venue rules to protect victims and speed up prosecution. So remember this clearly, class. The venue for illegal recruitment, again, it's RTC, the place of commission or place of residence of the victim. First court to take the case gets exclusive jurisdiction. So whenever you are asked, where should an illegal recruitment case be filed, always answer by asking, where did it happen? Where does the victim live? Or which court got the case first? Because in criminal law, venue is not mere technicality, it is jurisdictional. Now, let's talk about penalties for illegal recruitment. So this part shows us how seriously the law treats recruitment offenses, especially because they if affect livelihood, dignity, and public trust. Now, the penalties depend on whether the illegal recruitment is simple or constitutes economic sabotage. For simple illegal recruitment, the law imposes um, 12 years and 1 day to 20 years of imprisonment. So this already qualifies as a serious crime, reflecting the gravity of recruiting workers without authority. Then a fine of 1 million to 2 million. This fine, class, take note, is imposed in addition to imprisonment, not as an alternative. So, pwede siyang mapiriso and a fine. For illegal recruitment, um, which is deemed as economic sabotage, so meaning, again, in a large scale or syndicate, it carries much heavier penalties. So, sa imprisonment, class, it's life imprisonment. This underscores that the state considers large-scale or syndicated illegal recruitment as a serious threat to social and economy, and a fine of 2 million to 5 million. Again, class, this fine is imposed together with imprisonment. Now, the law mandates that the maximum penalty shall be imposed when the person illegally recruited is less than 18 years old or the offense is committed by a non-licensed or non-holder of authority. These circumstances reflect greater vulnerability of the victim or clear disregard of the law. So, remember this clearly. Simple illegal recruitment, it's imprisonment 12 years to 1 day to 20 years plus 1 million to 2 million fine. Economic sabotage, it's life imprisonment plus 2 million to 5 million fine. Because take note, class, illegal recruitment is never a minor offense. Okay? Take note, class. Recruitment is a regulated privilege. It is not a right. An abuse of that privilege leads to severe punishment. So in labor law, the heavier the harm, the heavier the penalty. So you read the cases, no, for illegal recruitment of People versus Navarra, GR number 119361, February 19, 2001. We have People versus Dolores de Leon, GR number 110391, February 7, 1997. We also have Gutierrez versus People, GR number 124439, February 4, 2004, and People versus Gasakaw, GR number 168448, 445, November 11, 2005. This the details of the cases class or the GR number is also reflected in our syllabus. Okay. Let's move on to the legal consequences and protections. No, we have been discussing from recruitment up to the termination of employment. So think of this as the accountability and remedies parts of labor law. First, let's talk about liabilities. Okay. So recruiters and employers may incur three kind of liability when they violated recruitment or employment rules. Number one, we have civil liability. So this involves payment of money, such as reimbursement of fees, um, unpaid wages and damages. No? Then we have administrative liability. So this includes suspension or revocation of licenses, fines, and other sanctions imposed by government agencies. And we have for serious violations like illegal recruitment, offenders may face criminal liability like imprisonment and criminal fines. So take note of this important rule class. There is joint and solidary liability between the recruitment agency and the foreign employer for violations of the employment contract. This means that the worker may go after either or both, whichever can provide relief. No? Then we have pre-termination of contract. So, especially in overseas employment. As a rule class, pre-termination must be for a just or authorized cause. So if the worker is legally or rather illegally terminated, the law grants the following entitlements. One, full reimbursement of placement fees. So meaning all fees paid by the worker must be returned and compensation of the unexpired portion of the contract. So the worker is entitled to what they should have earned for the remaining period of the contract. This protects class from arbitrary dismissal abroad. Um, as we discussed earlier, violations of recruitment and employment rules are not merely contractual breaches. These carry serious penalties, including fines, imprisonment, and loss of licenses. So the heavier the violation, the heavier the penalty. Then let's talk about remedies. Okay, so remedies available to workers. So meaning what workers can do when their rights are violated. So the workers may number one file a complaint. Asa man sila mo file? We have the POAA. Then we have NLRC or to the Dolly Regional Office, depending on the nature of the case. So they can seek relief such as reinstatement if it is still applicable, back wages, and damages. The law does not leave workers helpless. It provides clear avenues for redress. So as future HR professionals class and managers, you always remember this. Compliance prevents liability. Fair termination avoids penalties, and respect for workers' rights build trust and social sustainability. So in labor law, doing what is legal is not optional. It is essential. Okay, let's move on to employer-employer relationship, also known as um, EE and ER relationship. This is one of the most important and most litigated concepts in labor law. Why? Because before labor rights can exist, again, we must first establish whether an employer-employer relationship exists. Now, why employer-employer relationship matters? Again, because the existence of an employer-employer relationship determines whether labor laws apply, whether a worker is entitled to minimum wage, benefits, security of tenure, and protection against illegal dismissal. So, whether disputes also fall under labor jurisdictions, because without employer-employee relationship, the worker may be treated as an independent contractor or a non-employee service provider. Now look at the images here, no? Um, we have delivery riders, no? Then we have apps and gadgets. So this represents now the modern work arrangement, no? Such as food delivery riders, courier drivers, or mga app-based service workers. And a common question arise. So, our delivery, kanang tig-deliver ninyo sa mga parcel ba? Are delivery riders employees or independent contractors? No? So, the answer is not based on job title or contract wording class, but on how the work is actually performed. All right. Before we go deeper into labor rights and employer obligations, we must first answer a basic but very important question. Who is an employee? Okay. So this question may look simple, but in labor law, everything begins here. If a person is not legally considered an employee, many labor laws protection will not apply. Now, in ordinary usage, an employee is a person employed for wages or salary, especially at a non-executive level. So meaning mga rank and file employee. A person working for another person or a business firm to pay. Or in general, anyone who performs services for an organization. Now, these definitions, class, help us understand the idea, but labor law requires something more precise. Okay, so under labor law, an employee is a natural person, meaning tao gid ni siya, who is hired directly or indirectly by either a natural or juridical person to perform activities, no, related to the business of the hirer, who um under the supervision or control of the hirer directly or through an agent and paid wages or salary for the work performed. So notice the important elements here, class. Hiring, control of control or supervision, and payment of wages. So these elements distinguish an employee from an independent contractor or casual service provider. Now, in essence, and this is important to remember, an employee is a person who renders work or services to another for a wage. That wage may be computed on a one-time or a time basis, either daily, hourly, or monthly, or on a piece or task basis, as long as the worker is under the employer's control. Why is this definition matter? Okay, so it matters because once a person is considered an employee, class, they are entitled to labor standards and benefits, protection against illegal dismissal, security of tenure, and access to labor remedies. If a person is not an employee, these protections may not apply. Now, remember this guiding idea, class. It is not the job title, label, or contract that determines who is an employee, but the nature of the work the control exercise, and the payment of wages. So whenever you are faced with a labor issue, always ask first, is is the person an employee under the law? Because once that is answered, everything else follows. Now, after identifying who is an employee, we now move on to the other half of the equation. Who is an employer? So in labor law class, the relationship is always examined from both sides. No? Rights and obligations arises because there is an employer on one side and employee on the other. So, in its simple sense, an employer is a person or organization that employs people, or a person or business that employs one or more individuals, usually in exchange for wages or salary. This definition is broad and intentionally so because employers come in any forms. Now, under the labor law, an employer is more specifically defined as a person or legal entity that controls and directs a worker under an express or implied contract of employment and pays or is obligated to pay wages or salary as compensation. Now, there are three important elements here: control and direction over the worker, the existence of an employment contract, either written or implied, and the payment of wages or obligations to pay wages. So if these elements are present, the law will likely recognize the person or entity as an employer. Now, who can be an employer? So an employer may be an individual, such as a sole proprietor, or a juridical person like a corporation, um, a partnership, a cooperative, or any business organization. So take note, class, that what matters is not the form of the business, but the exercise of control and payment of wages. Okay? Now, employer-employee relationship class. Uh, Control is the key. So just like in identifying an employee, control is central in identifying the employer. So if a person or entity assigns work, sets rules and standards, supervises performance, and has the power to discipline or dismiss, then that person or entity is considered the employer, regardless of what the contract calls them. Now, take note that identifying who the employer determines who is liable, no, for labor law violations, who must pay wages and benefits, who may be sued in labor disputes, and who bears responsibility for illegal dismissal or contract violations. Now, in many cases, disputes arise because employers attempt to deny or avoid this status. So, remember this principle: an employer is the one who controls the work and bears the obligation to pay wages, regardless of label or business form. So when you analyze a labor situation, class, always ask who controls the worker, who pays the wages, and who has the power to discipline or dismiss. Because in labor law, authority brings responsibility. Okay. Now that we know who an employee is and who an employer is, the next question is, what is employer-employee relations? Now, this concept brings the two together, class. Okay? Employer-employee relations refers to the relationship between workers and employees in a business setting. It covers how workers and employers interact, how work is organized, how rights and duties are exercised, and how conflict are managed. Simply put, it is about how people work together within an organization. So, employer, the again, the focus of employer-employee relations class is the relationship between the workers and the business or employer. Now, this relationship is not only economic, take note, it is also legal, social, and organizational. It determines how decisions are made, how rules are followed, and how fairness is maintained in the workplace. Now, why is employer-employee relations important? This relationship is important, class, because it affects productivity and performance, employee morale and motivation, workplace harmony and conflict, and compliance with labor laws. When employer-employee relations are healthy, organizations tend to be stable and productive. And when they are poor, disputes, complaints, and labor cases arise. Okay, so for HR professionals, employer-employee relations mean balancing business goals with worker protection, ensuring compliance with labor law standards, and fostering cooperation rather than conflict. And take note, class, HR plays a key role in maintaining fair, lawful, and productive relationship in the workplace. So as we move forward, always keep this in mind. Labor law is not just about rules, it is about relationships. And good employer-employee relations are the foundation of a fair and productive workplace. Okay. Um, at this point, we already understand who an employee is, who is an employer, and what employer-employee relations mean. So, um, now we ask the most practical question: why is it important? No. Now, employer-employee relationship, class, is a key to success. Maintaining a strong employer-employee relationship is one of the keys to the success of any organization. When the relationship between the employer and the employee is healthy, respectful, and fair, everyone benefits. The employer, the employee, and the organization as a whole. So when employees feel that they are treated fairly, their rights are respected, and communication with management is open, they tend to be more productive, meaning they put more effort into their work. They tend to be more efficient, like they use time and resources better. They are more loyal. They are less likely to leave the organization. A satisfied employee is not just working for pay, they are invested in the organization's success. So, strong employer-employee relationship also help to create less conflict, like fewer disputes, grievances, and complaints. It improves cooperation, so smoother teamwork and coordination. Then build trust between management and workers. And of course, this reduces stress and creates a more positive work environment. Okay. Um, from a labor law and HR perspective, good employer-employee relations reduce the risk of labor disputes, illegal dismissal cases, and penalties for labor violations. Okay, so as future HR professionals, managers, or leaders, remember, treat employees well and they will work well. Respect rights and performance follows, and strong relationships build strong organization. Now, one of the most important tools in labor law is the fourfold test. So, this test, class, is used to determine whether an employer employee relationship exists regardless of how the contract is labeled. Remember this well, class. This is frequently asked in exams and in labor cases. No? Uh, fourfold test. Now, the fourfold test answers one basic question. Is there an employer-employee relationship? If the answer is yes, labor laws apply. If no, the relationship may that of an independent contractor or another arrangement. Now let's go through the four elements one by one. Number one, the selection and engagement of the employee. Okay, so this asks who hired the worker, no? Who selected or engaged the person to do the job. So if the employer has the power to hire, this element is present. The second element is payment of wages. No. This looks at who determines the compensation and who actually pays the wages or salary. Now, the employer does not have to pay directly as long as the employer controls or provides for the payment. These elements exist. The third element is the power of dismissal. So this refers to the employer's authority to discipline or terminate the employee. If the employer can remove the worker from service, then this element is satisfied. Then the fourth element is the power of control. This is the most decisive factor in determining the employer-employee relationship. It's the most important test. Okay, so here, the question is not what is the result of the work, but rather who controls how the work is done, who controls when and where the work is performed, who sets the rules, methods, schedules, and standards. If the employer controls the means and manner of work, not just the outcome, then an employer-employer relationship exists. Now, take note of this very important principle, class. Not all four elements need to be present in absolute terms, but the power of control carries the greatest weight. So even if the contract says independent contractor, the courts will look at actual control, not labels. So this test applies to delivery riders, app-based workers, freelancers, project-based employees, and traditional office workers. So the modern work arrangements do not remove labor protection if control exists. So memorize this clearly, class, the fourfold test. Selection and engagement of employees, so meaning the hiring, payment of wages, power of dismissal, and power of control. Again, the power of control is the most decisive factor. So whenever you are asked, is there an employer-employee relationship? Always answer by applying the fourfold test. And remember, control determines the relationship, and substance prevails over form. Now we focus on the strongest determinant, in establishing an employer-employee relationship. We have mentioned that a while ago, power of control. So among the four elements of the fourfold test, this is the most decisive. Control. So as a general rule, in the absence of power to control the employee with respect to the means and methods by which the work is accomplished, there is no employer-employee relationship. So it is not enough that a person works for another or is paid. What the law looks is control over how the work is done. take note, class, that not all forms of control are equal, no? So this is where students often get confused. The law recognizes that not every form of control creates an employer-employee relationship. That is why the courts draw a clear distinction between the two kinds of rules or control. The first kind of rule are those that merely serve as guidelines, aim only to achieve a desired result, and do not dictate the means or methods of doing the work. So, example, setting deadlines or requiring output standards or demanding quality results. So, these rules do not establish an employer-employee relationship class. They are consistent with independent contracting. Now, the second kind of rules are those that fix the methodology, bind or restrict the worker as to how the work must be done, control both the result and the means and manner of achieving that result. So, an example of that is having a specific work schedules, prescribed procedures, mandatory tools or methods, and close supervision of daily performance. Now, these rules create an employer-employee relationship. This line is very important, class. The second rule creates an employer-employee relationship. The first one do not. So in short, control over results only, then there is no employer-employee relationship. If the control is over the means and methods, then employer-employee relationship exists. Okay? This distinction class is crucial in cases involving the delivery riders, freelancers, project-based workers, platform or app-based employment. So even if a contract says independent contractor, actual control over conduct and performance still prevails. So remember this guiding principle. What matters is not just the parties for the relationship, but how much control is exercised over the work itself. So whenever you analyze a labor case, always ask, who controls the means and methods? Who dictates how the work is done? Because in labor law, control over conduct is the strongest determinant of employment. Um, there are other tests, although it is just supplementary. No? We have the economic reality test. So it looks at workers' economic dependence on the employer. And we have the two-tiered test. This combines control and economic dependence used in security and service contracting cases. We have here examples to better understand when an employer-employee relationship exists and when it does not. So first example, a truck driver in the course of his work does not have the freedom to decide where he will go, what he will do, and how he will do it. Because the employer controls these aspects of his work, the law considers him an employee, not a partner. The absence of freedom in work performances is clear indicator of an employer-employee relationship. Next, we have taxi or jeepney drivers operating under the boundary system are considered employees of the taxi or jeepney owners or operators. The same rule applies to passenger bus drivers and conductors. So even if they remit a boundary or do not receive as a fixed monthly salary, They remain employees because the operator controls their work, their routes, and their operations. Now, let's look at a contrasting example. Caddies in a golf club. Kay bang mo unsa ng caddy kanang tigbit-bit sa kanang kuan sa golf, no? Uh they are not employees of the club. They work there by tolerance of the club, and they are not required to observe fixed working hours. They are free to leave whenever they want, and they may stay away from work as long as they please. So, because there is no control over their conduct and work performance, no employer employer relationship exists. Finally, take note of this important point, class. A labor union or even an unregistered association may still be considered an employer if it has persons working for it. What matters is not the label again, but the actual relationship between the parties. So remember, where there is control over how work is done, there is employer employer relationship. Where there is freedom in work performance, then there is none. Now, let's discuss the evidence of being an employee. So, in labor cases, class, the existence of an employer employer relationship is a question of fact. This means it must be proven through evidence, not just by labels or claims. So, first, we have appointment letters or employment contracts. So these documents formally show that a person was hired by an employer and agreed to render services for compensation. Next, we have payroll records. So if a worker's name appears in the payroll, this indicates that the employer pays wages or salary, which is a strong indicator of employment. Third, the organization chart. So inclusion in an organization chart shows that the worker forms part of the company's structure and is subject to its hierarchy. Fourth, registration. Registration of the worker with the social security system by the employer is evidence that the employer recognizes the worker as an employee. Then fifth, personnel lists. This list identify individuals officially considered part of the employer's workforce. And finally, testimony of co-employees and subjection to company rules of conduct. So class statements from coworkers combined with proof that the workers follow company rules, policies, and disciplinary measures demonstrate the employer's control over the worker. So remember, there is no single piece of evidence that is conclusive. Courts look at the totality of evidence to determine whether an employer-employee relationship exists. That if there is no employer-employee relationship, there is no compulsory coverage under the Social Security law. Now, let's discuss the inclusive determinants of an employer-employee relationship. So these are the factors that may appear relevant, but do not by themselves prove the existence of or absence of an employer-employee relationship. Number one, we have contract. Okay, so the employment contract is not controlling. While the stipulations in a contract are relevant, they are not conclusive evidence of an employer-employee relationship. Again, class, an employer-employee relationship cannot be avoided simply by stating in the contract that no such relationship exists. So what matters is the actual relationship and the facts, not merely the wording of the agreement. Next, we have the basis of pay. Also, the kind of compensation agreement does not determine whether a worker is an employee or not. Compensation may not be based on the time spent on the job or not be based on the result of the work. So whether a worker is paid per hour, per task, per output, or per project, this is not decisive of employment status. Then third, we have the kind of work performed. So the worker's work may be vital, necessary, desirable, or even peripheral to the business. Whether the work is a core activity or a peripheral activity of the enterprise does not conclusively establish an employer employee relationship. The fourth one is the place of work. A place where the work is performed is not a sure indicator of employment. Okay, so an employee may work outside the business premises or away from the employer's office or factory. At the same time, a non-employee may perform work inside the premises of the business. Thus, location does not alone prove the existence of or absence of employee status. And finally, the length of service. The length of time a person is associated with a business does not automatically make him an employee. So what must still be shown are closer ties, such as subjection to company rules and regulations, or direct supervision over how the work is performed. Without these elements, class length of service alone is inconclusive. So remember this, none of these factors standing alone determines an employer-employee relationship. The decisive factor remains control over the conduct and performance of work. Okay? Now, for your assignment, you read the cases of Sonsa or read a case and digest these cases. Sonsa versus ABS-CBN Broadcasting Corporation, ABS-CBN Broadcasting Corporation versus Nazareno et al. We also have WPP Marketing Communications et al. Versus Jocelyn M. Galera and Smart Communication versus Astorga. Class, you concentrate on the concept of employer-employee relationship. You write your case digest in a short bond paper. The format should be the parties, no, and then you have facts, then issue, and how the court resolved the issue. Okay, thank you, and I hope you learn from this presentation, the employer-employee relationship concept. Bye.